This video is for research and educational purposes only. It does not constitute legal advice. If you need legal guidance, please consult a qualified legal professional in your jurisdiction. Today we're looking at a 2026 article by Professor Tan Cheng-Han from the National University of Singapore, published in the Chinese Journal of Comparative Law. The paper is titled COVID-19, Agentic Artificial Intelligence and Contract Formation. The central question of this paper is straightforward. When an AI system autonomously enters into a contract with minimal or no human involvement, how does the common law deal with it? Specifically, can such a contract be valid? And if so, what happens when something goes wrong? Tan addresses these questions through three lenses: agency law, contract formation rules, and the doctrine of mistake. The paper uses the Singapore Court of Appeal case Quoine PT Ltd v B2C2 Ltd as its primary case study throughout. Before diving into the legal analysis, Tan draws a distinction between two types of AI. Generative AI, like ChatGPT, is reactive. It produces content in response to user prompts. Agentic AI, on the other hand, is proactive. It is designed to make decisions and act autonomously, pursuing complex goals with limited supervision. Think of a smart home system that decides when to turn on the heating based on your energy goals, or more relevant to this paper, a trading algorithm that executes buy and sell orders on a cryptocurrency exchange without waiting for human approval. Tan notes that most real-world applications will combine both types, but it is agentic AI that raises the most pressing questions for contract law, and that is his focus. This brings us to the paper's most substantial section. Some scholars have argued that AI systems should be treated as legal agents. The logic is intuitive. If an AI agent exercises discretion in entering contracts on behalf of a user, it functions much like a human agent acting for a principal. Agency law could then distinguish between authorized and unauthorized acts, providing a principled framework for determining when a user should be bound. Scholars like Chopra and White, Go Ihan, and Lauren Scholes have each proposed versions of this argument, whether treating AI as full legal agents, constructive agents, or quasi-agents. Tan, however, rejects this position. His reasoning is multi-layered. First, agency law requires agents to be sentient, capable of thinking and acting. Software, however sophisticated, merely executes code. Second, historical analogies to Roman slaves or ships in admiralty law don't hold up under scrutiny. Roman slaves borrowed their master's legal personality, which is not analogous to software. Ship personification was a jurisdictional device, not a recognition of non-human agency. Third, and perhaps most importantly, granting legal personality to AI would require legislation, just as corporate personality required legislative intervention. Without it, courts cannot simply declare that a piece of code is a legal person. Tan also points to practical absurdities. If an AI had legal personality and acted without authority, it could be liable for breach of warranty of authority. But what would it mean to hold a program liable? The creditor would presumably want to seize the program itself, quite different from corporate insolvency where assets are distributed. He cites the 2024 Canadian tribunal decision in Moffat v. Air Canada, where the argument that a chatbot was a separate legal entity was rejected. The tribunal held that Air Canada was responsible for all information on its website, whether from a static page or a chatbot. Here is where Tan makes his most original contribution. Instead of asking whether the algorithm is an agent, he asks a different question. Was Quoine, the platform operator, which is undeniably a legal person, acting as an agent for the margin traders when it executed forced sales? Let me briefly recall the facts. Quoine operated a cryptocurrency exchange. In April 2017, a password change error caused Quoine's market-making program to malfunction, leading to abnormally thin trading volume. This triggered automatic margin calls and forced closure of two margin traders' positions. The platform placed market orders to buy Ethereum at the best available price, and because of the thin volume, trades were executed at roughly 250 times the prevailing market rate, approximately 10 Bitcoin for 1 Ethereum, when the market rate was about 0.04 Bitcoin for 1 Ethereum. Quoine reversed the trades the next day. B2C2, the counterparty, sued for breach of contract and won at first instance. Tan's argument proceeds as follows. The forced sales were not initiated by the margin traders. They were executed by Quoine's platform algorithm automatically. Quoine's own risk disclosure statement stated that Quoine, not the margin traders, may execute a compulsory reversing trade to protect users from escalating losses. There was no contractual provision deeming all platform-initiated trades to be the margin trader's own acts. Therefore, Tan argues, the forced sales should be understood as acts by Quoine on behalf of the margin traders, an agency relationship. If that is correct, the next question is whether Quoine had authority to make these specific trades. Tan argues it did not. The malfunction, not actual market losses, triggered the forced sales. The contractual conditions for Quoine's intervention were not met. As for apparent authority, the exchange price was so far outside the market rate that no reasonable counterparty could have believed the trades were made within authority. One objection to this analysis is that B2C2 didn't even know Quoine was involved. The transaction records showed only B2C2 and the margin traders. Tan addresses this by arguing that platform users' new trades could be initiated by Quoine in various capacities. He draws on the undisclosed principal doctrine. If the law allows a completely unknown principal to intervene on a contract after the fact, there is no good reason why agency cannot be established where it was merely not apparent on the face of the transaction. Had this argument succeeded, the trades would have been void as unauthorized transactions, and B2C2's claim should have failed. For ordinary user-initiated trades on a platform, Tan accepts the tool theory approach. The platform is simply a tool that facilitates direct contracting between parties. This is consistent with the classic English case Thornton v. Shoe Lane Parking, where an automated car park machine was treated as a tool of the proprietor, and with the Quoine Court of Appeal's own analysis. But Tan is careful to limit this. Tool theory works for user-initiated trades. For platform-initiated transactions like forced sales, agency analysis is needed, as we just discussed. And for non-deterministic AI systems, Tan leaves the question open, noting that it is not clear whether tool theory is always adequate. Within the tool theory domain, Tan develops what he calls an extended assent argument. Even though a user did not choose to enter into a specific transaction, the user chose to use the platform. That choice entails adopting the platform's processes and programming. There is, Tan argues, an objective assent to the process and therefore to the outcome, even if the outcome was unlikely or unpredictable. This is reinforced by existing legislation. The U.S. Uniform Electronic Transactions Act and Singapore's Electronic Transactions Act both expressly contemplate automated transactions where no individual reviews the electronic agent's actions in the ordinary course of forming a contract. Electronic records and signatures cannot be denied legal effect solely because they are in electronic form. If we accept that contracts can be validly formed through AI systems without human intervention, then the law of mistake becomes the critical safety valve for aberrant outcomes. Under common law, an operative mistake, meaning a mistake relating to a term of the contract, not merely the surrounding circumstances, negates consent and renders the contract void. The two recognized subtypes are unilateral mistake, where one party is mistaken and the other knew it, and common mistake, where both parties were mutually mistaken about a fundamental matter. In Quoine, the majority held there was no operative mistake. The deterministic algorithms had acted exactly as programmed. Knowledge of any mistake had to be assessed by reference to the state of mind of the programmers at the time they wrote the code. By that standard, B2C2's algorithm was not designed to exploit errors. Its deep price of 10 Bitcoin to 1 Ethereum was simply a failsafe to keep the system running. Lord Mance, however, dissented. He argued that the majority's approach examined the situation in the abstract and in advance, without regard to the actual transactions or market circumstances. In human intervention cases, the law considers the actual state of mind of each party in light of surrounding circumstances. The test, Mance said, should be what any reasonable trader would have thought, given knowledge of the particular circumstances. And in this case, the mistake was obvious. B2C2 itself emailed Quoine the next morning saying major Quoine database breakdown. While Mance agreed there was no unilateral mistake at common law, he held that the equitable doctrine applied. It was unconscionable to retain the benefit of transactions immediately recognized as erroneous. The contract was therefore voidable.
Tan expressly prefers Mance's dissent.
He argues that limiting mistake relief to cases where the programmer had actual or constructive knowledge at programming time leaves the doctrine with virtually no room to operate. It effectively immunizes a party from any counterparty mistake through the superimposition of an algorithm. Tan also highlights the striking disparity with the earlier Singapore case of Digilandmall, where the price differential was much smaller but relief was granted, the only difference being that a human, rather than an algorithm, accepted the offer. Finally, Tan points to the Uniform Computer Information Transactions Act, or USITA. This is a model law drafted by the U.S. Uniform Law Commission in 1999, intended for adoption by individual U.S. states. In practice, however, it was only adopted by 2 states, Virginia and Maryland later repealed it, so it never gained wide traction. Still, as a conceptual reference, USITA is interesting because it provides that courts may grant relief where electronic agent operations resulted from fraud, electronic mistake, or the like. He suggests this broad approach could extend even to non-deterministic AI. If the outcomes are beyond the contemplation of reasonable people, mistake doctrine should apply even without any flaw in the code. Setting the threshold at the level of a result beyond the contemplation of a reasonable person would provide a high bar to discourage speculative litigation while still offering relief for truly aberrant outcomes. That's a summary of Professor Tan Cheng-Han's 2026 article on COVID-19, Agentic AI, and contract formation. The paper offers a detailed rereading of the Quoine case through the lens of agency law, proposes that platform operators can be agents for their users in specific circumstances, and advocates for a more flexible approach to mistake doctrine in algorithmic contracting. Thank you for watching.